rather before the sample is provided immediately, will there be the right to counsel? Will that be part of this?
It's your service that might be on the front line on this issue.
Yeah, so my understanding of the new legislation is that once a demand is made, then if you refuse to submit the sample, it is taken as a refusal and automatically an offense. So at that point, yes, right to counsel. But pre that.
So if the person refuses to provide a sample immediately, so in your opinion, they would have the right to counsel or not?
Admitted once the refusal is made. Prior to that, there is no offense. There's a suspicion.
First of all, a comment, incidentally, people who are charged with driving while under the influence of alcohol do have the right to counsel before the breath test is demanded of them. And if it can be exercised, they're given the time to exercise it. So you might want to find out how it's going to work in this scenario as well.
Thank you. First of all, to Senator Sinclair's point on the right to counsel about roadside testing, I should say, for drug-impaired driving, why don't the people in this panel know that answer? And I imagine that people that are getting trained on this particular issue that's very soon potentially going to be the law in Canada, that needs to be a key part of it. But why don't the people that are here to testify about this to us today, why don't you guys know that?
I would say that at any point during a criminal investigation, if a person asks for counsel, then they would get the right to counsel. They would have it.
Correct, but this is going to be a major routine part of every particular roadside screening test, and I'm just really surprised that we don't have a quick answer. When Senator Carignan first asked it, I thought maybe it just wasn't being understood properly, but then when Senator Sinclair reiterated it,
yeah, I'll say that something was lost in the translation from my earpiece when Senator Carignan was asking the initial question, but certainly from the RCMP perspective, during any criminal investigation, when you're asking for right to counsel, then we make available counsel.
You make it available, but are they informed of their right to counsel? You're not sure, right?
So that's not the translation problem.
No. That's, I'm not sure why people on this panel don't know that. And there were a few times, actually, when Senator Carignan was asking your panel detailed questions and technical questions before. There seemed to be confusion. There seemed to be a kind of a reluctance to answer some of those questions. And maybe part of it is that, Mr. Boucher, you referenced on a few occasions, there's major challenges involved in testing for drug-impaired driving in Canada, given the remote, sparse locations that the RCMP polices in some areas of Canada. So considering all of this, I mean, it seems to me that this bill, C-46, and all of its provisions and all of its kinks to be worked out and all of its rigid training requirements to try to improve impaired driving in Canada and crack down on this big problem that we have, why wasn't it brought so much before a legalization of marijuana instead of basically at the same time or potentially coming into force in some ways afterwards?
Well, we already have drug-impaired driving in Canada.
Of course, yes.
We've been dealing with it for a considerable amount of time. We have DREs out there. They're being used. It's being processed. The blood demand part is only there if they can't provide a bodily fluid sample. I'll go back to the question that we were asking about counsel, and I would say, as we discussing this, that at the minute that an officer is in the process of gathering evidence, that we would be informing you ahead of time that you have the right to counsel.
Well, they're gathering evidence right from the moment you roll down your window.
Yeah.
Right?
Yeah.
Okay. I guess I'll leave it there. Thank you.
Thank you, Senator Batters.